Can you say something again?
A slight echo at the moment because I'm sitting close to DCJ at the moment, his computer at the moment, so it will be a slight echo.
Okay, that was not bad. That was not bad. Although it was breaking a bit, but I could hear what you said. I could hear what you were saying. It's not that bad, but I'm not sure when we're in the middle of the session how it's gonna be.
Tembani.
Jibu.
Tembani.
Morning, Reverend. How are you?
Fine, how are you?
I'm good.
Okay, it's fine. Rosan is correct.
How does it sound?
The computers are closed. It's fine. Tembani.
Okay. Yes, Reverend.
When Rosan moves to the other room, the echo will be eliminated. Don't worry about that.
Will be better. Okay. All right.
Yeah.
Okay. I've noted that. Thank you.
Recording in progress.
Hali, will you just position your camera and just switch it on because for production purposes? Just want to see if you are in a great space. The broadcasters are online. Mr. Ali. Mr. Ali. Can you unmute? Yeah, thank you. Nice background there. Perfect for the production. Just unmute, Mr. Ali. Mr. Ali, can you hear me? We can't hear you. We can see you talking, but we can't hear you. Tembani.
Yes, Rev.
Can you guys hear Mr. Ali? I can't hear him from my side.
No, I cannot hear him. I see he's moving his mouth, but I can't hear what he's saying. Mr. Hali, can you try to unmute yourself? There's a mute or unmute button. Because you are muted. You're still muted.
Good morning. We will commence with today's proceedings. Please turn on your cameras.
Recording in progress.
Good morning.
Good morning, Mr. Halley. Good morning, everybody.
Morning, Chair.
Good morning, Mr. Chair.
Good morning. Good morning. Good morning. Are we ready?
We are ready.
Thank you, Mr. Chair.
Yes, thank you. Thank you. Mr. Machvedi, it would be better if you put on your jacket.
Thanks, Chairperson.
Yes. Thank you. All right. This morning's session is to give various NPA officials, and I'm just trying to remember whether there are other officials other than NPA officials who had applied for leave to cross-examine certain witnesses who gave evidence implicating them, an opportunity to give a summary of their response to the evidence given by those witnesses. And the summary is meant to be a summary of what is contained in their affidavits, and they will do so through their counsel. Are you ready, Mr. Matwedi?
Chairperson, I'm ready. Chairperson,
Yes.
I'm being assisted by Advocate Ramai Mela and Advocate Matlanka.
Okay.
What we have decided to do is that I will deal with certain of the topics as set out in the summaries, and
Yes.
my colleagues will deal with others.
Okay, no, that's fine. That's fine. And you undertake all of you to complete within 2 hours, is that right?
Chairperson says that according to my watch, it's now 7 minutes past 10. So we did not start at exactly 10 o'clock.
Yeah, no, it will be 2 hours from when you start.
Thanks, Chairperson.
Yeah, okay, all right. Now you may start.
Thank you, Chairperson. The first portion that I'm going to start with is from page 7 to page 28, paragraph ending at 81, and therefore after that, Advocate Ramai Mela will take over.
Okay, maybe before you proceed, for the record, you can just you can place on record again who your clients are that you will be on whose behalf you will be doing this. And when I say you, I accept that it's you and your juniors. In other words, you may have decided to divide the work, but as I understand it, you represent a group of clients. But if you represent different clients within the group, you can make that clear as well.
Thanks, Chairperson. Chairperson, the implicated officials, that NPA officials that we represent are Advocate Pretorius, Advocate Paloyi, Advocate Maema, Advocate Matenjwa, Advocate Mukhatle, Advocate Chauke, and Advocate Mashuha.
Thank you. Thank you. Okay, that's fine. Thank you. You may proceed.
Thanks, Chairperson. Introduction.
You said you start from page
7.
Okay, thank you.
28.
Yes, thank you.
The implicated prosecutors' applications for the condonation of the late filing of the Rule 3.4 statements submitted, as well as the applications for the cross-examination of the witnesses who implicated them in state capture, were set down for hearing on 15 and 16 of June 2021.
Just 1 second. I'm sorry, Mr. Machivedi. Just 1 second. Please. Okay. Yes, thank you.
Sorry, Chairperson, for the purpose of the record, and error on my side, I forgot to mention Advocate Musing.
Oh, okay. Thank you.
Dr. Pretoria's application for the condonation of the late filing of his supplementary affidavit, leading of his evidence and cross-examination, as well as the cross-examination of Boyson and McBride, was set down for 25 and 28 June 2021. At the hearing of 15 June 21, the implicated prosecutors were informed by the chairperson that he was inclined to refer matters falling under the law enforcement work stream, including the implicated prosecutors' matters, to other agencies for further investigation, as the related investigations were not finalized and also due to time constraints. It is in light of these operational constraints of the Commission that the implicated prosecutors asked for and were granted leave to record their versions regarding evidence implicating them in hearings of the Commission. The recordal of the implicated prosecutors' versions was requested not just for the sake of an audience, but it is integral to the implicated prosecutors' constitutional right to a fair hearing and accords with the rules of natural justice. The notion of state capture is newly globally and locally. It is not yet legally defined in South African law. In dealing with submissions already made to the chairperson, alleging that the implicated prosecutors are implicated in state capture, it is important that all the relevant and available information be placed before the chairperson for consideration. This is pertinent to the development of state capture law in South African legal system. In light of the above, it is pertinent that the implicated prosecutors present their versions in the Commission so that the public may know why all the suspects were prosecuted or decisions were made to decline to prosecute, so that some forms part of the report of the Commission, considering that operational constraints preclude them from exercising their right to cross-examine those that implicated them. B, general overview, opening remarks. The judicial authorities, the comments that the chairperson made during the leading of the evidence of some of the witnesses who testified in the Commission, as well as the chairperson's announcement at the hearing of 15 June 2021 regarding the operational constraints of the Commission, provide a backdrop against which the summaries of the implicated prosecutors are recorded. The Constitutional Court, in the judgment of Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in the public sector, including state of organs, versus Jacob Gedle Yihlekisa Zuma, with regard to the public interest in the commission of the inquiry, stated as follows, open quotation. In addition to the function of advising the President, a commission of inquiry may also serve the purpose of holding a public inquiry in respect of a matter of public concern. The purpose of a public hearing under those circumstances is to restore public confidence in the institution in which the matter that caused concern arose. Here, the focus is not what the President decides to do with the findings and recommendations of a particular commission. Instead, the objective is to reveal the truth to the public pertaining to the matter that gave rise to the concern, open quotation, emphasis, close quotation. Similarly, the Constitutional Court, in the judgment of Minister of Police and others versus Premier of the Western Cape and others, explained the purpose of an investigative commission and the requirements of public purpose as follows. Open quotation, in addition to advising the executive, a commission of inquiry serves a deeper public purpose, particularly at times of widespread disquiet and discontent. In the words of Corey J. of the Canadian Supreme Court in Phillips versus Nova Scotia, one of the primary functions of public inquiries is fact-finding. They are often convened in the wake of public shock, horror, disillusionment, or skepticism in order to uncover the truth. In times of public questioning, stress, and concern, they provide the means for Canadians to be appraised of the conditions pertaining to a worrisome community problem and to be part of the recommendations that are aimed at resolving the problem. Both the status and public respect of the commissioner and the open and public nature of the hearing help to restore public confidence, not only in the institution or situation investigated, but also in the process of government as a whole. They are an excellent means of informing and educating concerned members of the public. There's a footnote number 3. I'm not going to read that for, due to time constraints.
Yeah.
In the matter of the chairperson of the Judicial Commission of Inquiry into State Capture, this is President of the Republic of South Africa. The Commission's chairperson, in motivating for an extension of the period for the Commission to complete its work, is said to have explained that the outstanding work yet to be conducted includes the investigation and or completion of investigations of allegations that the law enforcement entities such as the National Prosecuting Authority, NPA, the Director of Public Priority Investigation, DPCI or HOPS, or the Special Investigating Unit, SIU, may have also been captured. With regard to the functions of the NPA and the obligations on how its officials are to conduct their duties, the Supreme Court of Appeal, open bracket, SCA, close bracket, in the judgment of Zuma versus the DA stated as follows. The first respondent, open bracket, NPA, close bracket, as an organ of state, has a duty to prosecute without fear, favor, or prejudice by upholding the rule of law and principle of legality. It is also a constitutional body with a public interest duty. It behoves its officials to operate with transparency and accountability. It has a duty to explain to the citizenry why and how it arrives at the decision to quash the criminal charges against the accused persons, particularly where the matter involves very senior state officials. In pursuance of its constitutional obligations, it is incumbent upon the NPA to pass the rationality test and inform the public why it quashed the charges. In view, the convents would make the public lose confidence in the office of the NDPP, close quotation, our own emphasis. There is no doubt that the comments of the chairperson made during the evidence of Sisoko and Ngasana were to the effect that due to the grave and serious nature of the allegations leveled against the implicated prosecutors, he would request the evidence leaders and the investigators to obtain the relevant dockets and or information that the prosecutors had before them when they made decisions to either prosecute or decline to prosecute. The reason is that this will enable the commission to determine whether the implicated prosecutors had good reasons to recommend and institute prosecutions or to decline. Chairperson, I can say it without contradiction that all the dockets that were considered by the implicated officials were delivered and presented to the commission.
Yes.
The above sentiments expressed by the chairperson have been overtaken by time and more particularly the operational constraints of the commission. As such, the chairperson, as indicated in the introductory portion of this summaries, will no longer afford the implicated prosecutors an opportunity to appear before him and take him through the dockets and or any information they had before them in making decisions whether to prosecute or decline same. The allegations that the implicated prosecutors are captured either for political or corrupt reasons are based on conjecture and speculation. Conjecture and speculation are not sufficient to establish what is imputed to the implicated prosecutors. Similarly, there is no justification to infer wrongdoing on the part of the implicated prosecutors. In the matter of State versus Mutsweni, the court referred to tried legal principles pertaining to conjecture and speculation, which are different from inferences, and stated that inferences must be carefully distinguished from conjecture or speculation. There can be no inference unless there are objective facts from which to infer the facts which it is sought to establish. In some cases, the other facts can be inferred with such practical certainty as if they had been actually observed. In other cases, the inference does not go beyond reasonable probability, but if there are no positive proved facts from which the inferences can be made, the method of inference fails and what is left is mere speculation or conjecture. One, the inference sought to be drawn must be consistent with all the proved facts. If it is not, the inference can not be drawn. Two, the proved facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be doubt whether the inference sought to be drawn is correct. Role players and how some of them...
Sorry, Mr. Mathibedi. Of course, that quotation is appropriate in criminal matters. That approach to the drawing of inferences, namely the proved facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. That's appropriate in a criminal matter. Once you talk about drawing inferences in non-criminal matters, such as civil matters, then the test is different. Namely, you don't have to exclude, you have got to look at the most plausible inference. Is that correct?
That's correct, Chairperson.
Yes.
Chairperson, but taking into account the nature of the proceedings that we are dealing with, we respectfully submit that also this principle of this test is also applicable in this circumstances.
I would imagine that its applicability would be fine where the assessment relates to whether, in taking a certain decision whether to prosecute or not to prosecute, the prosecutor relied on acceptable inferences in weighing up the evidence, whether there would be enough evidence to prosecute or not. But in regard to whether, for example, I use the bold allegation, whether they were captured or not captured, that might be different. But where you say, was that decision that he or she took to prosecute this particular person or to decline to prosecute, if he or she relied on inferences, then those inferences would be guided by this kind of principle that you have quoted. But once it's something else, then it would be the civil kind of approach. Would you agree with that?
Chairperson, my submission is that because we are dealing with sui generis processes when it comes to the commission.
Yeah.
Our submission is that both are applicable, because our submission is that no concrete evidence was tendered before this commission in support of the allegations made by those who finger our clients as either being captured for either political or corrupt reasons.
Well, I guess in a way, because the commission won't be making any definitive findings, it's not so important for now.
Thanks, Chairperson.
Yeah. Okay. All right.
Role players and how some of the matters are interlinked. Rendition. Musing guided the investigation into allegations of the illegal extradition of Zimbabwean nationals who were killed and tortured after being handed over to Zimbabwean police by Maluleka of the DPCI and other members of SAPS. Initially, the investigation into the unlawful extradition of the Zimbabwean nationals was conducted by Mukangwe, a detective at the Detective Services in Mpumalanga, and JJ Mahlangu, attached to the Stock Theft Unit, Middelburg. 2 months later, Innocent Humbulani Kuba of the Independent Police Investigation Directorate, IPT, joined Mukangwe and Mahlangu and appointed other members of the IPT and led the investigation. On 22nd January 2014, Kuba prepared and signed a report and submitted the report and docket to Musing, who sent the docket and report to DPP South Gauteng. The report recommended that Generals Anwar Dramat, Shadrach Sibiya, together with Maluleka and other junior police officials be charged with, amongst others, kidnapping and defeating the ends of justice. On 3 March 2014, McBride was appointed the executive head of IP. On 6 March 2014, McBride instructed Kuba and Angus to retrieve the docket from the DPP South Gauteng. Kuba and Angus uplifted the docket on 7 March 2014. McBride instructed Kuba and Sissoko to review the evidence, and on 18 March 2014, the IP prepared a second report which recommended that Maluleka, together with other junior police officials, be charged with kidnapping and defeating the ends of justice. It no longer included Dramat and Sibiya. In April 2014, on the instructions of McBride, the docket and the report dated 18 March 2014 were delivered to Ngasana, who kept the docket unallocated until 13 January 2015, a period of approximately 8 months. In December 2014, the then Minister of Police, Nathi Nhleko, suspended General Dramat. Sometime in 2015, Nhleko appointed Werksman to investigate the issue of the 2 IP reports with different recommendations. A case docket of defeating the ends of justice and fraud was opened against McBride, Kuba, and Sissoko. In February 2016, Maema recommended that McBride, Kuba, and Sissoko be prosecuted. Dr. Pretorius agreed with Maema's recommendation. Dr. Pretorius, in line with the checks and balances envisaged by Section 24, (3) of the NPA Act 1998, consulted with DPP North Gauteng, Advocate Sibonkile Mzinyata, who agreed with the recommendation. Sometime in 2016, after the rendition docket had gone on a merry-go-round, explained in the relevant portion of this recordal, the docket was allocated to Baloyi, who finally took a decision to prosecute Dramat, Sibiya, and Maluleka. In 2018, Dramat and Sibiya made representations, and Baloyi recommended that the charges against them be provisionally withdrawn. The case is currently proceeding against Maluleka. The prosecutors involved in the rendition matter and the defeating of the ends of justice were Mosing, Baloyi, Mzinyata, Maema, and Dr. Pretorius. Sorry, Chairperson, my light just went off. I'm just asking for a moment.
Oh, okay. Okay.
There were, sorry, Chairperson.
Yeah.
There were various interlocutory applications, including review applications, against the issue of racketeering authorizations issued by Advocate Nomngobo Jiba, the then acting NDPP, on 17 August 2012, and Advocate Sean Abrahams on 13 February 2016. The review applications against the racketeering authorization issued by Jiba culminated in the judgment by Govan J. Boysens has relied on the findings of Govan J judgment before this commission and ignored the fact that in the judgment of GCB versus Jiba and others, Lekhodi J found that Govan J did not have the full facts before him. The findings made by Lekhodi J were supported in the SCA judgment when the matter went on appeal. Similarly, the Mokgoro inquiry also found that had the full facts been placed before Govan J, he may have come to a different conclusion regarding the finding of mendacity against Jiba. The current NDPP Advocate Shamila Batoyi appointed the DeKalb panel to reconsider racketeering authorization issued by Jiba and Abrahams. This resulted in the DeKalb report. The implicated prosecutors are of the considered view that the report is flawed in many respects as set out in their affidavits. For example, they point to the failure of the panelists to consult and solicit the views of the prosecution team to the questions that they stated they could not find answers to. Another example is that their summary of the evidence is in most respects patently incorrect. All of this pointed out in Maema and Matenjo's affidavits. And as a result of the Cox report, the racketeering authorizations were withdrawn by Batoyi, whilst the predicate charges were withdrawn by the current DPP-KZN. The implicated prosecutors who form part of the prosecution team are of the considered view and have demonstrated in their affidavits that the withdrawal was irrational, having regard to the decision of the SCA in the matter of Zuma versus Democratic Alliance and others, where the SCA, amongst others, held open quotation. The exclusion of the prosecution team from the final deliberations leading up to the decision to discontinue the prosecution appeared to have been deliberate and was in itself irrational. They were senior litigators steeped in the case, acquainted with the legal issues, and had a critically important contribution to make regarding the ultimate decision to terminate the prosecution's close quotation. In the relevant portions of this recordal, we cite out the summaries of the implicated prosecutors. The Amigos case. Advocate Steinberg was the prosecutor assigned to deal with the matter at its inception. He then left the NPA to join the International Criminal Court, and Advocate Cyril Simpiwe Mlotshwa, who became the acting director of public prosecution, DPP-KZN, assembled a prosecution team led by Advocate Ncedile Dunywa and consisted of advocates Sipunza, Vincent Ntanjana, and Makosini Mtembu. Spunzi and Tanjana later left the NPA and were replaced on the team by Advocate Bulelwa Vimbani. Mlotshwa signed the indictment in respect of the predicate charges on 31 August 2011. Although the formulation of the charges in the indictment was said to be defective by Advocate Johann Kruger. Kruger was the head of the Special Projects, SPD, and his responsibility was to process the racketeering charges before they got authorized by the NDPP in terms of Section 24 of POCA on the same date. Advocate Menzi Similani issued an authorization certificate in respect of racketeering charges. Mosing succeeded Kruger as head of the SPD, and in that position, he was mandated together with Advocate Lawrence Mukhwebi to assist the prosecution team in amending the indictment as Kruger's queries relating to the charges therein had still not been attended to. Mlotshwa was still DPP at the time, but was later replaced by Advocate Muiponi Noku. Upon finalization of amending the indictment, a decision was taken by Noku to withdraw charges against some of the accused, where it was found that the evidence available does not support the charges laid against them. SARS-related matter. The interception of communication at the Directorate of Special Operation, DSO, and the NPA offices. The above case relates to the unlawful installation of surveillance equipment and unlawful interception of communication at the offices of the DSOA and NPA by SARS High Risk Investigation Unit, widely known as the Rogue Unit. The existence of the Rogue Unit became public after it was widely published in the media. The publication referred to above also revealed that Rogue Unit was formed and operated in contravention of the law. The investigation that ensued resulted in criminal prosecutions, proceedings being instituted against certain SARS officials. The prosecutors who were involved in the above criminal proceedings are accused of enabling the state capture by McBride and Boysen. Early retirement of Ivan Pillay. During the investigation of the Rogue Unit case, a correspondence relating to Pillay's early retirement was discovered. Perusal of the correspondence revealed that the early retirement in question might have been granted in circumstances that are contrary to the applicable legal prescripts. But the prosecutors who were guiding the investigation in the Rogue Unit case directed that the early retirement issue should also be investigated. The investigations resulted in criminal proceedings being instituted against Oba Mahashula, Ivan Pillay, and Pravin Gordon. This too led to the prosecutors involved being labeled as enablers to the state capture, also by McBride and Boysens. CC refusal to charge Brigadier Sikele Kaba and others. Mr. Flock Semington, Meta Brooklyn case 790/10/2016. This matter is a sequel to the matter relating to police early retirement. After having been criminally charged, Magashula and Pillay made Section 179 open bracket 5 close bracket representations to the NDPP for charges against them to be withdrawn. Amongst others, in their representations, they mentioned that the manner in which Pillay's early retirement was handled was based upon an opinion that was prepared by Symington. When the matters of the investigation team went to obtain a statement from Symington, a standoff between Symington and the members of the investigation team ensued in relation to PCLU memorandum that Symington was in possession of. Flowing from the standoff, Symington laid criminal charges against the members of the investigating team and the bodyguard of the SARS commissioner. When the matter ultimately came before Baloyi, in his capacity as the acting DPP North Gauteng, he declined to prosecute. His refusal to prosecute led to him being accused of enabling state capture by McBride and Boysens. Camille Drefkas 12/01/2017 role players. Paul O'Sullivan, Sarah Jane, J. Trent, Temani Binang, and Mdlakaise Matlangu went to the home of the then acting police National Commissioner General Phahlane, and O'Sullivan falsely identified himself to the security officer and estate manager as a member of the IPID, a claim which Matlangu and Binang failed to correct. Security details relating to Phatlane's home and motor vehicles was asked for by O'Sullivan, and he also threatened the estate manager and architect of Phatlane's house with arrest if they did not cooperate with him. Advocate A. Geyser was the prosecutor who was charged with the responsibility of guiding the investigating team in regard to this matter. And after his resignation, it was allocated to Mashuge, who ultimately preferred charges against O'Sullivan, Trent, Binang, and Matlangu. O'Sullivan sent a flurry of threatening emails to Phahlane and Mashuge, the former of which formed part of the charges against O'Sullivan. McBride implicated Mashuge as part of the prosecutors who have acted improperly and or unlawfully and sought to, among others, unduly interfere in the investigative independence of the NPA, the IPID, and the Hawks. Standalone matters, withdrawal of charges against Mudluli. Mudluli was charged with kidnapping and murder of Mugibe. The docket was taken to the DPP SG for a decision. The possibility of referring the murder charges for an inquest was raised, and a view expressed that it was prudent to rather refer the matter for inquest and, depending on the outcome of the inquest, then proceed with kidnapping and murder charges in one prosecution. PCLU involvement in matters outside its mandate. The PCLU dealt with matters referred to it in terms of Proclamation number 46, 2003, published in the Government Gazette number 248276 of 23 May 2003, the proclamation, which set out matters that fell within its purview, as well as any other matter referred to it by the NDPP. The affidavits of Dr. Pretorius, Matenjo, and Maema deal with matters that were referred to the PCLU in terms of what is referred to as the omnibus clause. The omnibus clause relates to any matter that the NDPP refers to the PCLU for investigation and prosecution. Reference group, with the permission of the Minister of Justice and Constitutional Development, Matenjo was seconded to the reference group that was assembled by the Minister of Police, Natin Sheko, to advise him on diverse matters within his ministry. The reference group had terms of reference which define its scope. Among the items falling under the scope was the alleged involvement of the police members in illegal rendition. Matenjo was tasked to look into documents that contain allegations relating to rendition and brief members of the group on that. In the process of dealing with those documents, Matenjo realized that the rendition matter was being investigated by the IPID, and the investigating officer was Innocent Kuba. The group felt the need to meet with Kuba and requested Hadebe, who was the convener of the RG, to arrange same. Hadebe arranged the meeting, and McBride attended and briefed the meeting about the rendition. Matenjo's view was that McBride's view had nothing to do with the merits of the case they were appointed to advise the minister on. Members of the reference group were made to sign confidentiality clause. Secondment of Maema and Matenjo to PCLU vis-a-vis Ngasana's evidence before the commission. Maema and Matenjo, at the time that they were seconded to the PCLU, they were still dealing with the Cato matter. They both gainsay the allegations made by Ngasana that the commission, at the commission, that Ngasana told them that there was no evidence against Boysen. In fact, when the prosecution team briefed Ngasana about the Keita Mena matter, after he had summoned them to his office, he informed them that while still in private practice and representing clients who were being investigated by Keita Mena as VC, Ngasana told Peter George, accused number 3, and Nico Cross, accused number 18, that the whole story would eventually catch up with them. The prosecution team never had an opportunity to present a prosecution memorandum before Ngasana, such that Ngasana will be aware of the evidence in the docket and thus form the view that there was no evidence against Boysen. Prosecution of Paul O'Sullivan. All matters involving O'Sullivan were...
Just 1 second, Mr. Machibeji. I just want to mention that with regard to Mr. Ngasana, I do intend to deal with his evidence in the commission report insofar as allegations he has made mainly relating to the former president. So I don't think I would deal with that aspect that may relate to what General Boysen says and some of the matters, but I just mentioned that although it falls under law enforcement agencies, I do intend dealing with it from an angle that doesn't relate to matters such as what Mr. General Boysen is saying here. So I just mentioned that. I don't think it should affect any of your clients.
Thanks, Chairperson.
Yeah.
Chairperson, we've set out 3 cases that relate to Mr. O'Sullivan, and refusal to charge Khamanyane, Pretoria Central case 868/11/2016. This matter relates to a case that was opened by McBride, alleging that Mr. Israel Khamanyane was the acting head of IPID, mismanaged funds of the IPID. The matter was referred to Advocate L.B. Leonard S.C. Leonard, who declined to prosecute Khamanyane, which Baloyi concurred. Chairperson, whilst on this aspect, it's very interesting to note that despite Advocate Leonard being involved in this matter, he is not being referred to as one of those prosecutors that are captured either for political or for corrupt reasons. Whilst Baloyi, who is involved in this matter, is being referred to as one of those who are captured for either political or corrupt reason. This clearly demonstrates the selective condemnation of some of the implicated officials that we are attending to, so that we are representing. Kidnapping, defeating the ends of justice, contempt of court charges against the police officers who arrested O'Sullivan and Trent, Colonel I. Dawood, and others. Baloyi declined to prosecute Dawood and others for the charges of kidnapping, theft of cell phone, and imitation. Abrams agreed with the decision that Baloyi took. Prosecution of Glenis Breitenbach. Chairperson, there is a section that we are extensively dealing with that. I'm not going to read this brief one. And the prosecution of Jiba. Mokgatle drafted an opinion and refused to prosecute Jiba for defeating the ends of justice and fraud, which charges were premised on the finding made by Gorvin J. when he found that by failing to respond to allegations made in the affidavit of Boysen, she was mendacious. Mokgatle was of the view that the state will not be able to prove the element of intention, which is an element for both charges. Mokgatle's opinion was premised on the fact that when Jiba deposed to the affidavit filed in the review application instituted by Boysen, the prosecution team had furnished counsel for the NPA with all the necessary facts. The prosecution team in turn made statements to the effect that when they read the affidavit of Boysen, they prepared a memorandum for NPA's counsel to prepare a supplementary affidavit to deal with the issues raised in Boysen's affidavit. For reasons known to the prosecution's team, the NPA counsel did not prepare the supplementary affidavit, and thus full facts were not placed before Gorvin J. The failure to prepare a supplementary affidavit was also considered by Smith SC, the DPP, Northwest, who also declined to prosecute Jiba on the basis that Gorvin J did not have the full facts before him and that Jiba had no intention to mislead the court and thus did not perjure herself. Despite coming to the same conclusion as Mokgatle, Smith is not labeled part of the core group of captured advocates. Chairperson, what I would like to say about Advocate Smith is that he's one of the most senior and experienced prosecutors that the NPA ever had. Tenga, the then DP Northern Cape, also declined to prosecute Jiba on the grounds that the process to issue the racketeering charges was procedural despite this fact. Tenga formed part of the DECOP group panel that criticized Jiba's decision to issue the racketeering authorization. The report does not show whether Tenga disclosed that she had furnished an opinion contrary to the findings made in the DECOP report. Tenga is not referred to as part of the prosecutors that are captured for either political or corrupt reasons in respect of the Cato Mena matter. The only criticism leveled against her is that she chaired the disciplinary hearing of the IP's spokesperson, Moses Dlamini. Chairperson, unfortunately, we will never have an opportunity of knowing why Advocate Smith and Advocate Tenga were not condemned as it happened with the NPA officials that we are representing, because they are in the same boat as them. They are in the same category as them, Chairperson. Chairperson, Advocate Rama Meila will take over from here.
Okay, all right. Thank you, Mr. Matibedi. Thank you.
Thanks, Chairperson.
Okay. Is it?
It's Mr. Ramaimela, Chairperson.
Yes. Please go ahead. Welcome.
Thank you very much, Chairperson. Chairperson, you would have noted that it took my leader over 30 minutes to read, I think, about 28 pages, and we have been granted only 2 hours. So what I intend to do, Chairperson, instead of reading, because my portion, which deals with the rendition and the defeating/obstructing the course of justice, runs over approximately 55 pages. I will speak to the paragraphs
Yeah.
Where there is a need to emphasize, perhaps I can read those into the record.
Yeah.
But as I have observed, the chairperson has this summary in front of him, and
Yeah.
I trust, obviously, the chairperson has read it.
Yes, no, that's
Thank you.
fine. But also, they'll become public documents, and they will be available. Yeah.
Can I just inquire, is it just the recordal or including the affidavits that do run into hundreds of pages, taking into account that the rendition has 7 lever arc files as a docket and 1 lever arc file for defeating and obstructing the course of justice?
The affidavits will become public as well.
Thank you very much, Chairperson.
Yeah.
And I may just proceed. Chairperson, you will find the portion that deals with the rendition at page 129 of this recordal.
Yes, go ahead.
Thank you, Chairperson. And the way that this portion is drafted is, first, it deals with the opening remarks. Those opening remarks run from paragraph 303 to paragraph 305. The importance thereof, Chairperson, is just to request that the judgment of Akti Bolaghat, Hassel, and another versus Triomet, which was penned by Nugent J.A., as he then was, reminded all of us that in law, context is everything. And he referred to the judgment where Lord Steyn in R versus Secretary of State for the Home Department ex parte daily made that remark. Nugent J.A. went on further and said, and so it is when it comes to construing the language used in documents, whether the documents be it a statute or contract. So the purpose of that, Chairperson, was just to request that when these allegations were made, there had to be a proper context within which they were made. And because the prosecutor's versions will not, the prosecutor's cross-examination and their testimony will not be presented to the commission, that context obviously is missing because the public only has a version from only one side. What my learned senior did was to read a summary of the rendition. It is a very long docket, Chairperson. So what we will try and do is to present at least some of the evidence that was there, like the Chairperson has recorded, and we have referred in the recordal that during the leading of that evidence, I remember it was that of Mr. Sissoko, where you said to Mr. Sissoko that you would prefer to have the prosecutors come before you and tell you what evidence they had. You would have loved to look at the dockets to see what exactly was inside those dockets, so that you can determine whether the decisions they took at the time were within the bounds of the law. Be that as it may, Chairperson, we find ourselves here without the benefit of having to do all of that because of operational constraints. Now, that, Chairperson, is the opening remarks. Then at paragraph 306, which has numerous sub-paragraphs all the way to page 133, Chairperson, this is just a roadmap to give the reader of the portion as to what is going to be set out in the summary. We told you that we will deal with the general overview, the role of Advocate Musini, how he got appointed to guide the investigation, the investigations conducted by Mr. Kuba. You no doubt remember that he testified to it. Then we tell you the numerous IPD reports that had been prepared by Mr. Kuba, then the appointment of Mr. McBride, then Mr. McBride handing over the docket to Mr. Ngasana, the Werksman's investigation, its report and the transcripts, and then the role of Dr. Pretorius and Advocate Maema. Perhaps if I can just take a step back, Chairperson, the rendition matter ran through various prosecutors. Advocate Musing assisted in the investigation. That was his role. Then after the investigation had been concluded and the report of January 2014 was prepared by Mr. Kuba and handed in, Advocate Musing followed the necessary processes of informing the then acting NDPP Advocate Jiba and about the conclusion, and then the docket was taken to the South Gauteng DPP office, as it was the office which would have jurisdiction because there was centralization process going on and it would be given the jurisdiction. So instead of taking it to North Gauteng, they took it to South Gauteng. It was given to Advocate Chauke, the DPP, who allocated it to Advocate Van Zyl. All of that is set out later on, but just to give the sequence of the people who took part in what has been termed the rendition saga. Then obviously at that stage, it's no longer with Advocate Musing. When it's in the office of Advocate Zayas Van Zyl, Mr. McBride gets appointed in March 2014, the 3rd, I think it was. He takes over office on the 6th of March. Immediately on taking office, he instructs Mr. Kuba and Mr. Angus to go and retrieve the docket. They go and retrieve the docket, chairperson. Then the report of March 2014 is prepared. That report, we all know by now that it changed the recommendations of charging General Dramat and Sibia and only recommended that Captain Maluleka and other junior members of the SAPS be charged. Then instead of returning the docket to DPP South Gauteng, the docket gets taken to Mr. Ngasana on the instruction of Mr. McBride. Mr. Ngasana sits on the docket, for lack of a better word, chairperson, for 8 months, April 2014 all the way to January 2015, without allocating the docket. Then ultimately, the docket gets taken to Advocate Mzinyati and Baloyi, and that is where Advocate Baloyi comes in. Later, after they had read the docket, they take it back to Mr. Ngasana, who now takes it to South Gauteng. In South Gauteng, it appears that it was allocated to Advocate Roberts. At some point, the docket leaves South Gauteng again, finds its way back to Advocate Baloyi. But that is the web of explaining the role players, chairperson. Now, in the recordal, chairperson, at page 133, which is paragraph 301, we remind the chairperson of the evidence of Mr. McBride, which evidence was led on the 11th of April 2019, just to place on record the relevance thereof. Chairperson, you will recall that Mr. McBride testified and said that this rendition fiction is an American term. In the South African law, we don't have something called rendition. To the extent that we do not have such a crime, chairperson, Mr. McBride is correct. But what Mr. McBride failed to tell this commission and the public at large, chairperson, is what exactly is it that the people who were accused of having taken part in rendition did. Chairperson, at 309, we quote portions of your engagements with Mr. McBride, and I read you, after a series of questions from the evidence leader and Mr. McBride's response, the chairperson asked Mr. McBride, quotation, what is it that they were alleged to have actually done that was referred to being rendition? What was it? Just the actual acts as you understood them that was referred to as rendition. What was it? Now, chairperson, the recordal and the evidence of the implicated prosecutors who dealt with this matter, all the way from Advocate Musing to Advocate Baloyi, is that Mr. McBride failed to answer this question. The record does not contain an answer of what is it that he understood the actual acts to be rendition. Chairperson, we tried as best as we can to summarize 7 Lever Act files to condense the facts of what were the actual acts that constituted this rendition. We set that out, chairperson, from paragraph 312 to paragraph 314 with its subparagraphs, but because of the importance, chairperson, at least to the prosecutors who have been labeled all sorts of things of having charged for rendition or the defeating the ends of justice which emanates from this rendition. I will not be doing justice if I just don't read these paragraphs. The rest of the paragraphs I will speak to, Chairperson. Thank you very much, Chairperson. Now I'm reading from paragraph 311. 311 says, according to the affidavit of Musing, the actual acts that were referred to as rendition are the following. Now there follows the summary of all the statements, the documents that had been obtained by Kuba with the assistance of the others to set out the crime that had been committed. In the docket, Chairperson, there are statements which are to the effect that after a meeting between Generals Dramat and Sibiya had with their Zimbabwean counterparts sometime in August 2010, where they, amongst others, agreed to assist each other with cross-border crimes and extradition, Zimbabwean police arrived at the Beitbridge border post and requested entry into South Africa as they were due to have a meeting with Dramat. A police officer, Madilongo, who McBride incorrectly refers to as a crime intelligence officer, telephoned two of his superiors, informing them that about the presence of the Zimbabwean police officers. Madilongo's superiors instructed him to directly telephone Dramat and to seek his response. Madilongo directly telephoned Dramat on the cell phone number provided to him by the Zimbabwean police officers. Dramat then instructed Madilongo to permit the Zimbabwean police officers entry into the Republic. The Zimbabwean police officers arrived at the offices of the DPCI in Silverton and were introduced by Maluleko to his supervisor, Lieutenant Colonel Fester. The importance of mentioning this, Chairperson, is that other than Maluleke, who is an accused person, there is a statement of Colonel Fester who confirms that Zimbabwean police were introduced to her by Maluleke. The Zimbabwean police officers had a meeting with Dramat the next day. In the docket, there is evidence of statements and reports that indicate that indeed such a meeting was held between Dramat and police. Then after that meeting, Chairperson, an operation for the tracing and arrest of Zimbabwean nationals commenced on the evening that the meeting was held. Numerous witnesses deposed to affidavits confirming the presence of Zimbabwean police officers during various operations. The operations were conducted by Maluleka, an accused in the rendition matter, and members of the Tactical Operation Management Section referred to as TOMS, which operations were aimed at arresting the Zimbabwean nationals. The mandate of TOMS is set out in a document in the docket, Chairperson. After each operation and the arrest of Zimbabwean nationals, Maluleka and the police officers would personally drive the arrested nationals to Beitbridge border post and hand the arrested nationals, Chairperson, to the Zimbabwean side of the border. Each time the handing over was done, no extradition or deportation processes were followed. If I can just pause here, Chairperson, and remind the Chairperson that later in the summary, the prosecutors refer the Chairperson to a judgment that was quite interestingly penned by yourself, Chairperson, in S versus yes, Mohammed, Chairperson, where there was the issue of extradition. And the Constitutional Court said, if you know that the person that you intend to extradite may be killed, you do not do so. I don't need to remind the Chairperson of that. He knows it quite well. Now, I continue reading, Chairperson. Some of the Zimbabwean nationals handed over are alleged to have been tortured in police custody while others were killed. There is a statement of one of the persons who had been arrested in the operations, who had been taken over to the Zimbabwean side, who said he had been tortured and some of the people that had also been arrested were killed. Now, that are the acts, Chairperson, part of the acts that you were asking Mr. McBride, what constituted the rendition. Now, I continue, Chairperson,
let me just ask something, and I will remember later on to make sure you are not prejudiced because of the questions that I've asked you. So I'm counting the minutes, so I will add them at the back.
Chairperson, initially I only had 20 minutes. Now I've had to cut it down to 10 minutes. If I can just ask, if the chairperson asks me, how much more time will we be?
No, I'll look at how much time I'm taking. I'm delaying you, and then I'll add at the end of the 2 hours. I'll add to make sure that at the end, your whole team does not have less than 2 hours. So in the end, you must still have the 2 hours. So I'm going to bear in mind when I'm asking you a question. So what I wanted to ask is for just some understanding. Why was this matter referred to as a rendition matter in a criminal investigation context instead of just the normal crimes that we know? It's murder, it's kidnapping, it's whatever. Is that something you know? Is that something you don't know?
Chairperson, I think the answer would lie in the reports. If we had been given the opportunity, all the reports of the IPID, nowhere do they speak about rendition. They speak about kidnapping, and they speak about assault.
Yeah.
So the rendition may have been a term that was coined by the media when the allegations surfaced. You will notice in the summary, Chairperson, later on, if I can just tell you, even from paragraph 316 to paragraph 319, it's a very condensed summary of the report of the Police Civilian Secretariat. The Police Civilian Secretariat investigated this matter after it had been reported. I think it was in the Sunday Times that people were extradited to be killed in Zimbabwe. And then I cannot guess for the media, perhaps to sell the papers, they called it rendition. Because that was the term that was used, then everybody called it that. But in the docket, in the IPID reports, there is no use of the word rendition.
Okay.
I
think I'll be correct to say we probably took 3 minutes. So I took 3 minutes of your time.
I did. It was 11:02. Now it is 11:05. I am keeping the chairperson to his terms.
Okay, proceed.
Thank you, Chairperson. Now I was at paragraph 314.7, which appears at page 136. One of the victims, Makawe Sibanda, deposed to an affidavit and stated that when Maluleke paid him a visit after the arrest, he informed Maluleke that witness Ndeya, witness is the name of a person, Chairperson, was killed by Zimbabwean police whilst in custody, which is what had happened after they were handed over to Zimbabwean police. Maluleke allegedly told Sibanda that he knew they would get killed in Zimbabwe because that is what happens when one kills a police officer in Zimbabwe. The persons so handed to the Zimbabwean police were wanted in Zimbabwe for the murder of a Zimbabwean police officer, Superintendent Chitikobo. Now, Chairperson, from paragraph 314.9 with its subs, it's a summary of the four operations.
314.9.
314.9, indeed, Chairperson.
Yeah.
That is the summary of the operations that were conducted. You will see at 314.9.1, it's the first operation. It was conducted on the 5th of November 2010. It appears at page 136, Chairperson, where 4 Zimbabwean nationals were arrested and detained at Orlando Police Station. And then a few days later, 2 of the Zimbabwean nationals were illegally taken over the border and handed to the Zimbabwean police, while the other 2 Zimbabwean nationals were dropped off on the N14 freeway. Now, 2 of these persons were the Sibanda Makawe that I just referred to above, Chairperson, and he's the one who deposed to an affidavit which forms part of the docket. And then also, if I can just highlight that the documents that were used to hand over these people, the Home Affairs documents, were subsequently proved to have been falsified, and there is evidence in the docket from the officials of the Department of Home Affairs that the documents that were used were no longer in use at the time. And most importantly, at the time, the DZP, which is the dispensation for Zimbabweans, was in place, which prohibited their deportation for being illegal immigrants at the time, Chairperson. Now at SUP 2, it's the second operation, which was conducted on the 23rd of November 2010. The Zimbabwean national who was arrested, Richard Chuma, and he again was taken by Captain Maluleka in the company of Warrant Officer Silepe of Toms to the Zimbabwean police at Bait Bridge. Then the next SUP is SUP 3, a third operation that was conducted on the 11th of January. This third operation was conducted by Maluleke of the Hawks with the assistance, Chairperson, of Crime Intelligence Gathering. Maluleke requested the Crime Intelligence Gathering to help with the tracing of Gordon Dube. So to the extent that there has been evidence before this commission, Chairperson, painting the investigation of this matter as a crime intelligence-led investigation, that is untrue. Yes, there are persons who were from crime intelligence. All these persons, their statements are in the dockets and they explain the role. You will recall Madilongwa at the border is not a crime intelligence person. There's also the allegation by Mr. McBride that Mukangwe and Mahlangu, who were conducting the investigation before Kuba took over, were crime intelligence. That is also proven to be false. They were detectives. And it is only later when Advocate Musing took over guiding the investigation that he raised it with Mukangwe and Mahlangu to say, why is the IPID not involved in this investigation? And then they heeded his request. Chairperson would have noted that on the 10th of September, Mukangwe wrote to IPID to say, here is an investigation, can you take over? We are willing to assist. Ms. Kukimbeki in October 2012 assigned Mr. Kuba to establish a task team. Mr. Kuba took over the investigation and included Mukangwe and Mahlangu, who continued to investigate. All of that is in the docket. All of that is recorded in the investigation diary, Chairperson. Now to move on, SUP 3 is, I mentioned SUP 3, Chairperson, which is the operation of 11 January 2011, where Gordon Dube was arrested with the assistance of Technical Response Team, commonly known as TRT, as well as Crime Intelligence Gathering. And again, he was taken over to the border, handed over to Zimbabwean police. During his arrest, there had been a shootout with police, Chairperson, and a gun belonging to the Zimbabwean superintendent who had been killed was found in his possession. Captain Maluleka took this gun, which the investigating officer in the matter of Dube needed as an exhibit for the crimes against Dube in South Africa. He took it over to Zimbabwe, Chairperson, therefore obstructing the course of that other investigation. We leave it at that. All of that evidence is in the docket, Chairperson. Now, subparagraph 4 is the fourth operation, which commenced on the 26th January 2011. And that is where a Zimbabwean national by the name of Johnson Nyoni was arrested, again with the assistance of TRT. And this is where it stated that he is taken to Silverton at the offices of the Hawks, DPCI. This is where some of the statements indicate that General Dramad came to the members and congratulated them for the success in the operations. Now, Chairperson, excuse me. Those are the summaries of the operations. When you turn the page over at 139, you will find, as I've already referred to you paragraph 316 all the way to 319 at page 139 to 140. It is the summary of the Secretariat of, let me just make sure, report of the Police Civilian Secretariat chairperson. You'll remember just now I just said she investigated because of the reports in the media. Then once she investigated, she also considered the reports of the DPCI that had been given to the minister when he was being asked questions in the National Council of Provinces and in the National Assembly, Parliament, wanting to know what exactly is happening, because this has potential for a diplomatic crisis because foreign nationals are involved and proper processes are not followed. Now, the minister was given information notes to respond to Parliament, and these notes were prepared on information that had been given by the DPCI. The Police Secretariat considered that the versions in these notes was questionable and contradictory, and then she recommended that the IPID or a retired judge investigate. Now, we don't know why the matter was investigated by Mugangwe and his colleague instead of going to the retired judge or IPID directly as recommended by the Police Secretariat. Be that as it may, I have explained it was investigated by Mugangwe and Mahlangu, who after obtaining few documents, we set them out, chairperson, that at the time that they approached Advocate Jiba to assign a prosecutor to assist, there was about 7 statements and 3 other documents in the docket. And then Advocate Jiba appointed Advocate Musing to assist. That, all of that starts at paragraph 320. Then you will see that we set out at 322 and 323, the statements of the 4 crime intelligence officers who were seconded at the time, chairperson, to TOMS, which was led by General Sibia. Now, all this mention of crime intelligence, we assume is the basis on which it is alleged that it was a crime intelligence driven investigation. But we also submit that it is betrayed by the objective facts that are in the docket. And a slanted version has been placed before this commission and told to the public. Then, chairperson, also what was in the docket at the time were 3 other statements of the victims of the arrest. And you will recall Makawe had been taken to Zimbabwe, tortured, and then made his way back. Now, with this evidence, it's not enough, but there is some sort of evidence which points to a crime of a person being arrested for being an illegal immigrant, taken not by Home Affairs and not through extradition, by a Hawks police officer to the border to Zimbabwe. The prosecutors have a duty, as my senior has referred to the decisions and the Prosecuting Act, to assist the police to investigate, and where they identify a prima facie offense, not a prima facie, yes, they have a duty to take the matter to court. Now, chairperson, interestingly enough, Mugangwe asked Advocate Musing, can you issue warrants of arrest? We mentioned that at paragraph 325. Then Advocate Musing says, no, I cannot issue warrants of arrest. These investigations are very incomplete. There are numerous questions that arise from the few statements that are in here. Go and investigate all these other issues. He sets them out. They are in the police diary. Mugangwe and his colleague go and investigate. Later on, I have stated chairperson Kuba gets appointed. Kuba's appointment starts at paragraph 328 at page 142. At all these pages, chairperson, we set out the steps that Mr. Kuba took when he investigated, when he obtained the witness statements, when he obtained the documents of Home Affairs, which shows that proper processes were not followed, when he obtained the DZP, and this led to Mr. Kuba preparing his report of 22 April 2013. So the report of January 2014 was not the first report. He had been preparing interim reports, giving them to the then acting executive director, Ms. Kukimbeki. The first report, we set out a summary of it, Chairperson, at 336. It appears at page 145. We set out the evidence that Mr. Kuba had obtained at that stage, obviously including that which already existed in the document. Of importance, we also set out, Chairperson, at paragraph 337 and 338, that there is a statement of, what's his name, Nietling, who was attached to the DPCI provincial offices in Gauteng. The importance of the statement of Nietling, Chairperson, is that at least here is somebody who is not attached to crime intelligence, who also corroborates what the people who had been seconded to Toms, but from crime intelligence, said. He also says that he had instructed his junior, Selepe, to escort Maluleke when one of the suspects, Chuma, was driven to Bait Bridge. So that is very important evidence, Chairperson. It finds its way in the IPT report of 2013 April. Then from paragraph 341 all the way to paragraph 347, Chairperson, it's an IPT report of 2 July 2013, where Mr. Kuba accounts for all the investigations that he has conducted. And to answer the Chairperson's questions earlier, at 342, Kuba concluded the report with possible charges of kidnapping, contravention of Immigration Act, forgery, and assault. There's no rendition there, Chairperson. Now, Advocate Musing is still guiding the investigation. He prepares a memorandum to account to his superiors. It's dated 7 July 2013. Then the investigation continues, Chairperson. Mr. Kuba prepares another report. It's dated 4 September 2013. We set out the summary of that report, Chairperson, at paragraphs 348 to paragraphs 350. And then thereafter, Chairperson, it's another report of the IPIT. It is dated 22 October 2013. Excuse me. Now, Chairperson, in this report, there are notes from Advocate Musing, who raises certain question with Mr. Kuba to say, what about this? Follow this aspect up, follow that one up. And when you record your annex charts, please put an exhibit number like your A1, A2. He's guiding the investigation. He's not investigating. Mr. Kuba is investigating. It's a very high profile matter. It involves generals in the SAPS. So it is important that, proper work be done and that those who are responsible be held to account. So that is the role of Advocate Musing in the whole so-called rendition saga, Chairperson. And then comes the report of 22 January 2014 that you will find at page 154, Chairperson. It starts paragraph 361 to 364. It sets out what the report was all about. And you will recall, Chairperson, when the evidence was laid before you, that this report recommended that Generals Dramat and Sibia also be charged together with the other junior officials, Chairperson. Then Advocate Musing prepares a memorandum of 14 February 2014, where the docket gets referred to South Gauteng. I've already told you that facts, Chairperson. You'll remember when it gets taken to South Gauteng and then it gets allocated to Advocate Zayas van Zyl, from whom Mr. Kuba and Angus retrieved the docket. Then in paragraph 371, Chairperson, all the way to paragraph 386, we set out that it is quite interesting that Mr. McBride gets appointed on the 3rd of March, that you find at 371. And immediately upon his appointment, Chairperson, he is already phoning Angus on the 5th of March. That you will find at paragraph 375. And he is instructing Kuba to say, I want a briefing. Kuba briefs him, then he wants the docket to be uplifted. And he's saying that the evidence in the docket must be reviewed. This is a person who's been in office for merely 2 days, and already he's asking for a review of the evidence. He doesn't say, I want to see what the evidence is. And then after he has read 7 Lever Act files, he says, yeah, no, actually go and review this, that, and the other on the report. You will also recall, Chairperson, from the evidence that Mr. McBride's version has been consistent that he never saw the January 2014 report. He only was told about it. He actually, if my memory serves me well, he saw it the next year after General Dramat had been suspended. Be that as it may, Chairperson, all of that is in the docket, all of that is in the affidavits, and what this is merely a summary where we try to point to the Chairperson that when you have regard to the probabilities, what had been happening here does not seem to be above board. You can't come on the 6th of February, on the 18th, work or an investigation that had been conducted over a year changes. And then of importance, Chairperson, also is that after the change of that report, instead of it being taken back to Advocate Zayas van Zyl, where it was taken from, it gets taken to Mr. Nxasana. Now, Mr. Nxasana, instead of either taking a decision, which he can, he doesn't take it. Neither does he take it to any other prosecutor to read it and take a decision or make a recommendation. He sits quietly 8 months. In that 8 months, Chairperson, you will note in the recorder, Dr. Pretorius said he considered that together with Mr. Maema when they were charging or taking a decision to charge for defeating the ends of justice, that in that 8 months, Mr. McBride is giving media reports. There are questions in the public domain. What has happened? Mr. McBride says Generals Dramat and General Sibia have been exonerated by the IPID. The prosecutors take serious exception to the word, in fact, to the use of the words exonerated. Only a court can exonerate. The IPID makes recommendations. Now, they are of the considered view and the firm belief that in the docket, no evidence justified the changing of the recommendations. In fact, if regard is held to the investigation diary, Chairperson, from the time that the docket was uplifted from Advocate Van Zyl to the time it's taken to Mr. Nxasana, only 3 new entries are made. Those entries, it's the report of the civilian secretary. There is also a report of, if I can just refresh my memory, Chairperson, there is also a report of what has been referred to as an expert, whose expertise is not told, but what she did is that she examined the statement of one of the key witnesses, being Madilonga, who allowed the Zimbabwean police entry into the Republic, and said that the statement of Madilonga is unreliable because Madilonga uses 5 pronouns in one sentence. With the greatest of respect, Chairperson, Madilonga is a Venda-speaking police officer, just as I am a Tswana-speaking advocate. When your mother tongue is in Venek and you are writing in another language, you are bound to use pronouns and not write to the satisfaction of Anna Marie van Staden, who questioned Madilonga's statement. Now, the prosecutors are of the view that that statement could not justify.
I just wanted to remind you and your colleagues that I'm not controlling how long you take. I leave
yes, Chairperson.
To you and your team. So yes. I'm not going to say stop. So it's between you and your
me and my team. Chairperson, I do realize that I've taken long. If I can just take the Chairperson quickly to, I've already spoken about Mr. Ngasana, to the investigation conducted by Werksman's chairperson. You will see that from page 166, paragraph 400, we've set out the investigations of Werksman's, and then at page 170, paragraph 408, we've set out the interviews that Werksman's conducted with Mr. Kuba, and we've pointed, chairperson, to what the prosecutors consider to be very noteworthy portions of the transcript where Mr. Kuba appears to give a sense that the change of the report was at the instance of Mr. McBride. And in fact, he says he was called to come and sign the report. And because he was told that his boss, Mr. McBride, was happy, he couldn't question anything and therefore had to sign the report. All of that is set out in the paragraphs I've just referred the chairperson to. Now, chairperson, from paragraph 412 all the way to paragraph 425, we set out the affidavits of Dr. Pretorius and Advocate Maema insofar as it pertains to the rendition, to the defeating of the or obstructing the course of justice. Now, what they are asking is that background that I've just set forth is what they considered. It is the context that Nugent J.A. was referring to. It may not all be set out in the one docket of defeating, but that is the context. And because Mr. McBride had been going on the public domain saying there's no evidence against Ramat and Sibia, he was obstructing the course of justice. And together with that evidence and the contents of the defeating of the ends of justice, they took a decision to prosecute for that charge. And it had nothing to do with being captured. And then, chairperson, from paragraph 426 to paragraph 445, this is a summary of the evidence or the affidavit of Advocate Baloyi, who is dealing with the rendition matter. He is prosecuting Captain Maluleka, and as I have already intimated, or my senior has already intimated during the introductory part, that Ramat and Sibia made representations and a decision was taken to provisionally withdraw the charges against them. I don't intend to go into the details of the affidavit of Advocate Baloyi, because the evidence that he has considered is part of the evidence that I have been narrating to the chairperson, that Advocate Musing assisted Mr. Kuba when he was investigating the matter. Chairperson, on that score, that concludes the rendition and defeating the ends. I take my leader, or Advocate Madlanga, will be next. Thank you very much, Chairperson.
Yes. Okay. All right. Thank you. Thank you.
Thank you.
Mr. Madlanga. Mr. Madlanga.
Good morning, Chairperson.
Good morning. Good morning. Are you ready?
I'm ready as Chairperson. I'm just struggling to get my picture on the screen.
Well, we can see you. Now we don't see you. Now we see you.
You can see me?
Yeah, I can see you now.
Good morning, Chairperson. Chairperson, I've been allocated to read into the record the topic dealing with the SARS-related cases.
Yes.
This, Chairperson, is captured on pages 82 to 106 of the filed summaries.
Yes.
This topic is dealt with under 3 headings.
I'm sorry, I was making a note here that it starts from what page?
page 82 to 106, Chairperson.
Okay, all right.
Of the summary.
Okay.
This topic is dealt under 3 headings. The first one being the interception of communication at the offices of the Directorate of Special Operations and at the offices of the National Prosecuting Authority.
Yes.
The prosecutors that were involved in the SARS-related matters generally were Dr. Pretorius, Advocate Maema, and Advocate Baloyi. Starting with the interception of communication case, the case involving this interception at the DSO and the NPA offices was widely publicized in the media under the headline SARS Rogue Unit. In this summary, the prosecutors implicated refer to the above case also as the Rogue Unit case, whereas the official name of the unit was the High Risk Investigating Unit. In a nutshell, Chairperson, the Rogue Unit matter is about whether SARS officials installed listening and monitoring devices at the offices of the DSO and the NPA. If such devices were installed, it is important to be established who authorized such installations, on what authority did such a person rely. If it was SARS management, where it is important to establish whether SARS has the statutory authority to authorize and to carry out such surveillance. The implicated prosecutors demonstrate that SARS had no authority to authorize and or conduct such surveillance. The prosecutors further demonstrate by reference to legislative prescripts and witness statements that SARS is not statutorily authorized to act as it did. Also, there is undisputed evidence that SARS officials installed such surveillance equipment in the offices of the DSO and the NPA. And lastly, SARS in fact carried out the unlawful interception of communication. The Rogue Unit owes its origin to the memorandum dated 2nd of February 2007, which was written by Mr. Pillay in his capacity as the General Manager of the Enforcement and Risk Division of SARS. The memorandum was directed to Minister of Finance at the time, Mr. Trevor Manuel, seeking approval for the funding of special capability within the former National Intelligence Agency, currently known as the State Security Agency, to supply SARS and other law enforcement agencies with the necessary information to address illicit economy from where SARS was losing a lot of revenue. From that memorandum that was written by Mr. Pillay, the following can be gleaned, Chairperson. One, the purpose of the memorandum was to seek approval to fund a special capability within NIA to supply SARS and other law enforcement agencies with necessary information to address the illicit economy. Mr. Pravin Gordhan, SARS commissioner at the time, approved the recommendation on 8 February 2007. Mr. Jabu Muleketi, the former Deputy Minister of Finance, approved the recommendation on 22nd of February 2007. Mr. Muleketi's approval was accompanied by a handwritten comment stating, I quote, "Supported. However, this is a strange way of executing what I consider to be an economic mandate of NIA. it seems as an add-on rather than part of NIA's mandate, close quotes. Mr. Manuel, the former Minister of Finance, approved a recommendation on 22nd of February 2007. Lastly, in paragraph 2 of the memorandum, it is acknowledged that SARS did not have statutory authority to conduct covert surveillance on anyone. Mr. Muleketi confirms this in his written comment when supporting the recommendation. It is worth noting that from the reading of the memorandum, the initial intention for establishing the unit was good and perfectly in order. Also, the manner in which it was intended to be established and conduct its business was legally permissible. The investigation confirmed that the rogue unit did exist. However, the rogue unit's establishment was not in accordance with the law. The rogue unit also did not conduct its business in accordance with the law. Consequently, certain SARS officials were criminally charged. The said officials were charged of contravening Section 49, subsection 1 of the Regulation of Interception of Communications and Provision of Communication-Related Information Act number 70 of 2002, amongst others. The above mentioned charge relates to the unlawful fitment of surveillance equipment in the offices of the former DSO and the NPA and the interception of communication in those offices. Basically, what is criminalized by Section 49, subsection 1 of RICA is the intentional interception of communication without authorization of a designated judge in terms of Section 16 of RICA. Mr. Helhard Lombard made and submitted a statement in terms of Section 204 of the Criminal Procedure Act in relation to the above case. In his statement, Mr. Lombard confirms the following. One, he was an employee of SARS at the time. His immediate supervisor, Mr. Andres Janse van Rensberg, who in turn reported to Mr. Pillay. He, with the assistance of Mr. van Rensberg, to some extent fitted the surveillance equipment in the offices of the DSO and NPA. On instruction of Messrs. van Rensberg and Pillay, he intercepted communication of the DSO officials using the surveillance equipment that he and Mr. van Rensberg installed. The installation of the surveillance equipment and the interception of the communication were conducted without authorization of a designated judge in terms of Section 16 of the RICA. Lastly, after Mr. van Rensberg had left the employ of SARS, Mr. Johan van Locherenberg took over Mr. van Rensberg's position, and the unit continued to conduct surveillance still without Section 16 authorization. Evidence given by Mr. Lombard above is corroborated by Messrs. Yapi Chabalala, Eric Kulegani Kwela, Dilo Nyapudi, Dani Leroux, and Francois van Niekerk, as well as Miss Nora Pizzi. All the above witnesses were SARS employees attached to the rogue unit at the times relevant to the case. Mr. Johan Daniel Duval also corroborates the evidence given by Mr. Lombard. Chairperson, if regard is had to the content of the memorandum of 2 February 2007, prepared by Mr. Pillay it is clear that Mr. Pillay and everyone who supported the contents of the memorandum knew that SARS did not have the statutory authority to carry out surveillance. In addition to Mr. Lombard's confirmation of installation of the surveillance equipment at the DSO and the NPA offices and the interception of communication, Colonel Isaac Johannes Fisher confirmed the capability of the surveillance equipment as indicated by Mr. Lombard. Copies of the statements of the individuals referred to above were in the docket and are attached as annexures to the Rule 3.4 statements of the implicated prosecutors filed with the Commission. In view of the evidence set out above that was before the implicated prosecutors, they were justified to institute criminal proceedings in this regard. They submit, Chairperson. Now, Chairperson, I come to the second topic under the SARS-related matters. This one relates to the early retirement of and pension payout to Mr. Pillay. The matter relating to the retirement of Mr. Pillay surfaced during the investigation of the rogue unit case, when a correspondence relating to it was discovered. The investigation referred to here was guided by the Priority Crimes Litigation Unit, as it had been referred to it by the NDPP in terms of the proclamation. On perusal of the correspondence, it appeared that SARS might have incurred unauthorized, irregular, and fruitless and wasteful expenditure in respect of the early retirement of Mr. Pillay. It appeared very improper that SARS could pay a retirement penalty for an employee, particularly when an employee takes an early retirement due to purely personal reasons. Since the PCLU must guide and manage the investigation of matters referred to it and matters incidental thereto, PCLU was obliged to request the investigators to investigate Mr. Pillay's pension payout and guide the investigation in that regard. The investigation revealed that the manner in which Mr. Pillay was granted early retirement was in contravention of the law relating to pensions. It was meant to assist Mr. Pillay to sort out his personal problems relating to the schooling of his children. The approval of Mr. Pillay's early retirement by the Minister of Finance was coupled with the recommendation that almost immediately after retirement, Mr. Pillay would be reappointed by SARS to occupy the same position he occupied before taking retirement. That is the position of the Deputy Commissioner, even though the reappointment was on contract basis. The reappointment of Mr. Pillay was done without following the correct procedure. For instance, the position was not advertised, and therefore no interviews were conducted. Based on the above, Messrs. Mahashula, Pillay, and Godan were criminally charged. It is worth noting the following in relation to the criminal proceedings that were instituted against the three above. The prosecution team did not have Mr. Symington's statement in the docket when the decision to prosecute was taken. Mr. Symington was at the relevant time employed by SARS at its legal and policy department. He prepared an opinion upon which it was alleged that the decision to approve Mr. Pillay's early retirement was based. The prosecution became aware of the existence of Mr. Symington's opinion on 14 October 2016, when Messrs. Mahashula, and Pillay made representations in terms of Section 179, subsection 5 of the Constitution for the withdrawal of charges against them. The prosecutors who were involved in charging the three above were accused of instituting malicious prosecution against them. This allegation is leveled against the said prosecutors, coupled with the allegation that they, together with others referred to in General Boysen and Mr. McBride's affidavits, enabled state capture by persecuting corruption busters and by refusing to prosecute politically connected individuals. It is not the individuals who were charged that accuse the prosecutors of malicious prosecution, but it is General Boysen and Mr. McBride. Be that as it may, considering the sui generis nature of the proceedings of the Commission, the prosecutors must still respond to the unsubstantiated and baseless allegations that General Boysen and Mr. McBride made against them. The charges against Messrs. Makhashula, Pillay, and Mr. and Godan were the following. One, it was fraud in that a false pretense was given to SARS and National Treasury to its prejudice, that SARS was liable to pay in excess of R1 million to the GEPF on behalf of Mr. Pillay, which was a penalty for taking early retirement for personal reasons. Two, contravention of the Public Finance Management Act by causing SARS to incur or failing to prevent unauthorized, irregular, and fruitless and wasteful expenditure. A further fraud in that a false pretense was given out to the human resources of SARS to its prejudice to enter into an employment contract with Mr. Pillay for a remuneration package for a period of 5 years instead of 3 years, which was in the approved memorandum, which was approved by Minister Godan. A further fraud in that a false pretense was given to human resources of SARS to its prejudice to enter into an employment contract with Mr. Pillay for a period of 4 years when there was no approved internal memorandum or letter authorizing it. The prosecutors who were involved in the prosecution of this case, being Dr. Pretorius and Advocate Maema, demonstrate in their respective Rule 3.4 statements filed with the Commission that, based on the objective evidence that was before them, they were justified in recommending to the NDPP that the individuals referred to above must be prosecuted. They demonstrate that there was a reasonable prospect of successful prosecution in the matter. In the paragraphs that follow, the implicated prosecutors demonstrate that there was a rational basis to bring charges against the three individuals. The following evidence was in the docket when the decision to prosecute was taken. On 12 August 2010, the former commissioner of SARS, Mr. Makhashula, requested the former Minister of Finance, Mr. Godan, to approve the early retirement of Mr. Pillay from SARS with full retirement benefits with effect from 1 September 2010, and that SARS must pay the early retirement penalty that is payable to GEPF as contemplated in Rule 14.3.3b of the GEPF pension law, read with Section 19 of the SARS Act and Section 16(2)(a) of the Public Service Act. Approval was also sought for Mr. Pillay to be reappointed almost immediately after retirement in the same position as the Deputy Commissioner on contract for 3 years. Effectively, Mr. Pillay would be enabled to pay for his children's education and continue his employment at SARS for another 3 years, whilst SARS would suffer financial loss in excess of R1 million. Provision was made in the memorandum for the former Deputy Minister, Mr. Nhlanhla Nene, to recommend the proposal, but the former Minister, Mr. Gordhan, approved the early retirement without Mr. Nene's signature. Mr. Nene explained that he had no recollection of the memorandum being presented to him for comment. After Mr. Pillay went on early retirement, Ms. Magashula entered into an employment agreement with Mr. Pillay in the same capacity for a period of 5 years, commencing on 1 January 2011, knowing that the approval granted was for a period of 3 years only. And lastly, just before Mr. Gordhan was appointed as Minister of Cooperative Governance and Traditional Affairs in May 2014, he extended Mr. Pillay's contract for another 4 years when there was no internal memorandum authorizing such extension. When Mr. Pillay's employment contract was to terminate in 2016, the contract still had a year to 2 years, in fact, to run before it expired. Also, at the disposal of the implicated prosecutors, there were 2 undated memoranda which were written by Mr. Pillay. The one was addressed to Mr. Magashula and the other to Mr. Gordhan. In the one addressed to Mr. Magashula, he mentions the reason for his early retirement as, I quote, "I was expected to perform at a very high level, accompanied by accountabilities that go with the performance of such a high level job. This exerted its toll from me in the sense that my health condition is slowly deteriorating. Adding to this, my family responsibilities for a long time suffered on account of the dedication required by my job. I have decided to take early retirement," close quotes. In the one addressed to Mr. Gordhan, he states, I quote, "I have reached a stage in my life where it has become a reality that I had to make some very important decisions about the education of my children. The decision I have taken will require a considerable capital investment, money that can be raised by means of a bank loan, but which would be prohibitively expensive in view of the current financial circumstances, where very high rates of interest are the order of the day, and indications are that this situation will prevail for the foreseeable future. In view of this, I have decided to inform you that I intend to retire in 2009 when I reach the age of 56 years. As I have already reached the earliest optional retirement age of 55 years in terms of SARS retirement provisions, the retirement benefits will provide me with a lump sum benefit which will financially support the decision I have made in terms of the education of my children, as well as a monthly pension. Whilst this may not be ideal in terms of the maximum benefits when finally retiring, I am of the opinion that this is the best option available to me as far as my children's education is concerned. This brings me to the second issue at stake, namely how I view my retirement as raised above. Clearly, I'm doing this on account of a matter that has nothing to do with my work at SARS. I still feel that I am still capable of doing my work. I still have the enthusiasm and will to do it, and I am of the opinion that through my work, I can still contribute to the establishment of an even better South Africa for all its citizens, close quotes. The implicated prosecutors held a view that the separate reasons for early retirement are quite different and contradict each other. Section 16, subsection 6, paragraph A of the PSA requires that the executive authority may authorize an employee to take early retirement if there are sufficient reasons to take such early retirement. In their view, the reasons advanced for such early retirement contradict each other and are purely personal and have nothing to do with his obligations towards SARS. The officials at Human Resources warned Mr. Makhashula that implementation of the decision would amount to SARS paying for the education of Mr. Philane's children, but they were simply ignored. In addition to the three memoranda referred to above, the implicated prosecutors had the following documents in their possession, which they considered when making the decision to bring the charges in issue. The first one is the affidavit of Mr. Nico Johannes Khomotso. At the relevant time, Mr. Khomotso was an employee of SARS. In his affidavit, he says, I quote, "In 2008, I was instructed to prepare a ministerial memorandum to be signed by Mr. Godin, who was Commissioner of SARS at the time, to recommend to the then Minister of Finance, Trevor Manuel, that he approve Philane's early retirement. I awaited the approval by the Minister of the request by Mr. Philane. In October 2009, while waiting for the approval of the memorandum, I received a revised memorandum from the Office of the Commissioner, Mr. Oupa Makhashula. The memorandum contained different reasons from my original memorandum as to why the minister should approve Mr. Ivan Philane's early retirement. The reasons on the revised memorandum were that Mr. Philane wished to go on early retirement in order to enable him to provide for his children's education, and not, as I have previously stated, that he wished to pursue other interests. I raised concerns to the commissioner through the emails dated the 8th and the 9th of October 2009, respectively, that if the minister should approve Mr. Philane's application on the grounds of personal interest, may create a precedent in terms of which other employees might come forward with similar requests for early retirement, close quotes. In the email...
Mr. Mahlanga, we are at 12 o'clock. I propose to add 10 minutes to cover for the 2 or 3 questions that I asked. Is that fine with you?
Chairperson, for me to finish, I may say I still needed about 10 minutes, and my learned leader, Mathibedi SC, is also intending to still come.
Well, from 10 to 12, that's 2 hours, but you know, I promise that because Mr. Mathibedi didn't start exactly at 10, I would add, and also for a few questions. So I propose to add 10 minutes, but let me do this. Let me add 15 minutes. We go to 15:15. How your team uses it, let me leave that to you. Is that fine?
Thank you, Chairperson. Because Chairperson, I know Mathibedi SC still needs to address you, Chairperson. Yeah. Maybe yeah. I should at this stage stop and give time to him.
Maybe take 5 minutes to wrap up. Then I'll see how I accommodate him within. I won't give him a lot more, but take 5 minutes to wrap up your section.
Thank you, Chairperson. In a nutshell, Chairperson, the implicated prosecutors demonstrate that in the docket that was before them at the time when they decided to institute the criminal proceedings against Mr. Pillay, Mr. Magashula, and Mr. Godan, actually supported the decision in that there were reasonable prospects of a successful prosecution, considering the evidence that was before them.
Mm.
If I may quickly move on to the last topic under this, the SARS-related matters, it relates to the refusal to prosecute Brigadier Kaba and others who were investigating the rogue unit.
Mm.
The implicated prosecutors in this case, the implicated prosecutors in relation to the above matter were Dr. Pretorius and Advocate Baloyi.
Mm-hmm.
This matter emanates still from the investigation that was conducted in relation to the rogue unit. After the documentation in which it was discovered that there was this early retirement payout to Mr. Pillay, when Mr. Magashula, Mr. Pillay, and Mr. Godan were charged, later Mr. Magashula and Mr. Pillay made representations to the NDPP in terms of Section 179, subsection 5 of the Constitution. And in the representations they made mention of the fact that their decision to approve the early retirement was based on an opinion that was given by Mr. Symington, who was in the legal department of SARS. Then the PCLU instructed the investigating team to get a statement from Mr. Symington. And in guiding that investigation, Dr. Pretorius wrote a memorandum which he sent to the investigating team led by Brigadier Kaba. And Brigadier Kaba forwarded that memorandum to the attorney contracted to SARS, who in turn forwarded it to Mr. Moyana, who was the commissioner at the time. Mr. Moyana forwarded the memorandum to Mr. Symington Sr. to discuss it with Mr. Symington. When the investigating officers visited SARS to take the statement from Mr. Symington, they realized that he knew the issues that were raised in the PCLU memorandum. And they indicated to the commissioner that they were not happy that he was having that document with him because they were fearing that it might be leaked to the media. Then the commissioner instructed his bodyguard to accompany the investigating team to go and retrieve that document from Mr. Symington. And on their arrival, Mr. Symington refused to give it to them. And there was some standoff. But ultimately, they managed to get the memorandum from him. And he later laid criminal charges against the DPCI investigating team members and Mr. Titi, the commissioner's bodyguard. When that docket ultimately came to Advocate Baloyi, he declined to prosecute. And the reason, amongst others, was that Mr. Symington made two statements, and there were contradictions in those statements, which Advocate Baloyi was of the view that they made they impacted negatively on the successful prosecution of the case. Hence, he declined to prosecute. That is the reason, amongst others, that he is labeled by Mr. McBride that he is a member of the core group that was enabling the capture of the state.
Yes.
His decision, Chairperson, is actually in a way supported by the decision of Fabricius J. when he was dismissing the application that was made by Mr. Symington based on the same facts. He was of the view that there was no threat at all that was exerted against Mr. Symington on the day. He even says that, in fact, there's a passage quoted from the judgment of Fabricius J. He even says that the standoff could have been resolved by a handshake and over a glass of beer. That Advocate Baloyi views as supporting his position to decline to prosecute.
Yes.
Mr. Symington and his legal representatives also requested a certificate of non-prosecution, which was given almost 4 years ago. Up to date, no private prosecution has been instituted, and that also Mr. Advocate Baloyi submits that it's an indication that Mr. Symington and his legal team also realized later that there is no success, there are no prospects of a successful prosecution. With that, Chairperson, I should end to say that Advocate Baloyi in this regard submits that what is said by Mr. McBride against him cannot justify the label that he is enabling the capture of the state. Thank you, Chairperson.
Thank you, Mr. Matlanga. Mr. Mathibedi?
Thanks, Chairperson.
I give you 10 minutes. Is that fine?
That's fine, Chairperson.
Yes. Okay. All right.
Thanks, Chairperson. I'm dealing with Cato Manor. 28 people died at the hands of the police officers, of which General Major Boysen was leading. Now, it's very important to indicate that what is surprising is that despite the fact that reliance is placed on self-defense by the members, none of the members sustained injuries, even not a single police vehicle was damaged during the incidents. And of critical importance is the evidence that in some of the scenes, firearms were planted by members of the Cato Manor unit. And ballistic evidence revealed that some of those firearms that were retrieved by members of the Cato Manor were not functional. Even, a bullet could not be fired from those firearms. And the most outstanding incident, Chairperson, relates to a 16-year-old boy, Kwazin Dlovu. And I've been in contact with the parents. The father says justice has failed him. We have a 16-year-old son who was shot dead. More than one bullet hit the young boy whilst in the rented house during the evening whilst he was asleep. And the allegation is that they were acting in self-defense. Now, if we have to look at the evidence of a member of the police, Brigadier Mangena, who dispels the notion that Kwazin Dlovu was posing any threat or a danger to the police. The evidence reveals that at the time that he was shot, he was lying on a couch. And the father says at the later stage, I was asked a question as to who is the person that was shot, and he said, it's my son. and the operation ceased. And what's disturbing is that we have here members of the police who can utilize the services of the police intelligence to determine whether the people who escaped from prison are the people who are staying in that house, which turn out that they are not. And we also have an incident of a person who was shot dead in a wheelie bin. You know, the photos reveals that the shooting happened from the top, as the lead, has got some holes. Chairperson, we respectfully submit that Advocate Mahema and Matenjwa demonstrated in the affidavit the evidence that was available at their disposal that led to the laying of the initiation of charges against Poisons and other members. And we must also bear in mind that Poisons is one of the implicated persons. And there are all reasons why he is condemning Matenjwa and Mahema. And it is not even his evidence that he went through those dockets to establish what the kind and nature of evidence was in those dockets. And of critical importance is that it is not even his evidence that an internal investigation was made by him to determine what is it that happened during those shooting incidents. Chairperson, we respectfully submit that their charging was justified. And the other aspect relates to the DeCock report. We've set out in what respect this evidence, this report is flawed, which report was used to withdraw the charges against Poisons and his colleagues. Chairperson, the other thing relates to the involvement of Paul O'Sullivan in the investigation that transpired at the house or home of Mr. Phahlane. Once it is acceptable that in certain circumstances witnesses or complaints are entitled and are allowed to go to a house of a suspect to go and do whatever pointing out should be made. But in this regard, Chairperson, we respect that went beyond what was expected of a witness. And also there is a report there which indicates as to why it was untenable or undesirable for Paul O'Sullivan to have been involved in that investigation. And on his own version, McBride says, I am aware of the kind of person Paul O'Sullivan is, but he did not set boundaries for him and said, you can only go up to this extent, which that did not happen. And also evidence is there, Chairperson, which demonstrates that what kind of person O'Sullivan is. The plethora of emails that were sent to Tory Pretorius, that was sent to Phahlane, that was sent to Mashukge. We respectfully submit, Chairperson, that there was sufficient evidence that necessitated the charging of O'Sullivan, Trend, and members of the IPIT. Similarly, also the charging of Advocate Breitenbach. And of critical importance is that as matters stand now, there is no statement emanating from Breitenbach who makes allegations that, my charging was because of, was politically motivated, Chairperson. Chairperson, we respectfully submit that the only crime or sin that the implicated officials committed is because they did their statutory duties and obligation, as was expected of them, without any fear, favor, or prejudice. Whichever decision they took, whether to prosecute or to decline to prosecute was legally justified. Chairperson, lastly, we would like, on behalf of the implicated NPA officials, we would like to take this opportunity to thank the chairperson for having given us a platform in this commission to tell this commission and the world that the allegations leveled against the implicated officials are malicious. They are unfounded. There is no merit in that. They are based on conjecture. Such was merely meant to, take away or shift away their unlawful conduct, which they committed. The very same people that points a finger at the implicated officials, they are the ones who actually are criminals. They are not, crime busters as they seek, the community or the public should believe, Chairperson. We thank the Chairperson for that opportunity, for having given them the opportunity, at least for them to have a say. Thanks, Chairperson.
Thank you, Mr. Machibedi. Thank you very much. So we will end it here.
Chair, if I could just mention.
I have already indicated previously what's going to happen. Thank you very much. Thank you, Mr. Hali, to you as well.
Thank you, Mr. Chair. If I might just mention, if you don't mind, Mr. Chair.
Yes.
You'll recall that Mr. Sissoko and Mr. Kuba's representative, Mr. Bart Ford, had applied before you previously for leave to put in a summary of their own and to receive the summary. Now, I've been contacted by Mr. Ford during the adjournment, who's reminded me, and he's asked me to remind you, that during the course of dismissing his application, you had indicated that that you would reconsider that position if the need arises. Now, Mr. Ford, I understand, is on the link, and he might want to address you on that. I just draw that to your attention.
No, I won't allow anybody else to address me, but the summaries are public documents now, and they may have them. But this is where we will end this part of the.
Thank you, Mr. Chair.
The hearing. I am going to adjourn for about 15 minutes, and then I will resume to enable somebody else to provide summaries, read summaries in regard to another implicated person. So the position with regard to this is the end for now. And any of the witnesses who had given evidence may have these summaries, but I'm not going to allow any further evidence or address in regard to these matters, because this, I have indicated, I'm not going to make any findings, and I'll make recommendations for these to be subjected to other processes. Everybody will get a chance to do so in such processes. Thank you to everybody concerned. We'll adjourn for now. I'll resume after 15 minutes. We adjourn.
Thanks, Chairperson.
Recording stopped.
Good day. We will resume today's proceedings. Please switch on your mic
Recording
and
in
camera.
progress.
Good afternoon, Mr. Halley again.
The next piece, the next portion of evidence will relate to Mr. Extian of BDK Attorneys. He will be given a summary in respect of his client, who is Lieutenant General Phahlane. And Lieutenant General Phahlane has been given an opportunity through Mr. Extian to read a summary of his evidence in relation to the response to Mr. McBride and Mr. Sissoko.
Yeah. Mr. Extian, are you there?
Good afternoon, Chair. I'm here.
Good afternoon. Good afternoon. Thank you. You appear for Lieutenant General Phahlane, is that correct?
That is correct, Chair.
And you confirm that you will be giving a summary of Lieutenant General Phahlane's affidavits in response to the evidence or affidavits of Mr. McBride and Mr. Sissoko, is that right?
That is correct, Chair. I will deal with both, as the allegations of Mr. Sissoko and Mr. McBride are basically the same. There's only one aspect which I intend to handle in regarding to Mr. Sissoko's evidence.
Yes, and also you confirm the understanding that this is once this has been done, then your client will no longer be seeking to pursue cross-examination.
That is correct, Chair. We understand that fully, and
yes. Okay, all right. Is it fine if I give you 30 minutes? Obviously, you are free to finish earlier than 30 minutes.
I'm sure that that would be sufficient, Chair.
Yes, okay. Go ahead.
Thank you, Chair. Chair, I believe the statement of my client is in front of the Commission. It was quite a lengthy statement regarding the one of McBride, Mr. McBride's evidence as well. That I think the statement with all the annexes amounts to over 500 pages. So I apologize that we did not do a summary which was then forwarded, but I'm just going to, from the statement, highlight some portions which we think is essential that the public should hear regarding the allegations that was made against General Phahlane in this matter.
Yes.
Chair, I'm going to start on his statement regarding the evidence of Mr. McBride on paragraph 333, whereby General Phahlane clearly says that the allegations that was made against him in front of the Commission during the testimony of Mr. McBride is totally not new to him. This is allegations come a long way back. Since 2009, he was implicated, negatively implicated, and there was negative publicity and undue attacks all the time since 2009 on General Phahlane.
Yes.
After Mr. McBride returned in 2016 to the office of IPID, the allegations then ensued by him and Mr. Paul O'Sullivan, who worked closely together with Mr. McBride in the investigations. Now, I think the Chair would know that during the evidence of General Mabula and Brigadier Nube, when they had the opportunity to cross-examine Mr. McBride even conceded that the involvement of Mr. O'Sullivan was not as it was supposed to be, because he was not interacted as an investigator according to the IPAD Act, or he was being seen as a complainant. There was reasons given why they involved him, but Mr. McBride conceded that it was wrongful and that his involvement was a bit overboard. Now, Chair, I'm going to go further on to say the paragraph 35 of the statement is that during June 2012, there were certain allegations made by pop crew members regarding unlawful practice that took place at the Forensic Service Division, where General Phahlane at that stage was the divisional commissioner of the Forensic Services Department. He immediately then, after this, informed the then National Commissioner, General Phahlane, about these allegations, and he requested that these should be investigated immediately, as he felt that he needs his name to be cleared and his division to be cleared of any wrongdoing in any part. This was being done, and General Phahlane instructed an outside forensic accounting services, CPN, to conduct a thorough forensic investigation into the allegations which were made. Then, in December 2016, the same allegations made by Pop Group, and which was investigated by CPN, again came peddled by McBride and O'Sullivan in the national media and before the committee of the Parliament by Mr. McBride. Now, the CPN has, after the investigation in 2012, gave a thorough report, which is also in front of the Commission, attached to General Phahlane's affidavit, and I think which is self-explanatory, and we do not need to give exactly what all is, but they found that there was no wrongdoing on General Phahlane's side, or then there were certain aspects which they pointed out which needed to be attended by the National Commissioner and other persons of the SAPS. Then General Phahlane I'm just so sorry for that, Chair. I just want to go through quickly here. On the 16th of May 2017, General Phahlane had to appear before the Portfolio Commission Committee of the Police in Parliament after allegations that was made by Mr. McBride on the 4th of May before this Portfolio Committee regarding allegations of corruption and all things like that, counter charges that apparently were being investigated, and other wrongdoings, which he then asked the Portfolio Committee to intervene. General Phahlane and members of the SAPS did attend this parliamentary hearing in front of the Portfolio Committee, and they addressed all the aspects before the chairperson, then Mr. Francois Beekman. This was all because of allegations which was made by Mr. McBride before the Portfolio Committee on the 4th of May. Now, one Chair would remember that I think during the testimony of Mr. McBride, he is the one that said that he was dragged to Parliament by General Phahlane, which is now totally incorrect because it appears that he was the first one who was in front of the committee, and General Phahlane was then basically asked to come to this committee, and not like Mr. McBride wanted this committee to believe that he was dragged to the Parliament committee. And therefore, General Phahlane just want to correct that as well in this aspect. General Phahlane says that he indeed wants to credit Mr. McBride for having learned exceptional well from his masters and handers in unleashing a propaganda machinery on a target, which General Phahlane felt was him in this matter, and in being relentless in his efforts to cause harm and reputation of those in his sight. The stratcom that was waged against the struggle seems to be what he admired, and he did not let an opportunity to pass without him applying such to his benefit. He therefore salutes Mr. McBride in this regard. This, despite the pain and hurt General Phahlane had to go through as in his person and character. Okay, I'll go on to before April-May 2016, General Phahlane has not ever met Mr. Robert McBride. You've heard about him, but you have never met him in person or seen him or anything. And then he was highly surprised on a day that he came out of his house and he saw that Mr. McBride is at his house. He was driving a E200 Mercedes at the time, and he was accompanied by a lady at that stage. Mr. McBride introduced himself to General Phahlane, and he then informed General Phahlane that the reason why he's there is just to come and talk to him, because he's also of the view that General Phahlane is like him under attack. It is noteworthy to note that at that stage, McBride was also suspended from IPEC. He then told General Phahlane to say to him that the people do not want us good people, and they will do everything in their power to fight us. Now, General Phahlane at this stage did not understand what he was saying about this, but he took it up that because of his suspension and all the allegations that was now made against General Phahlane, could have been this for him to say or make this remark to say they want us good people out and will do everything to get us out of our positions. He then further said that they are using the media to attack us, and that him and General Phahlane should be careful. McBride also cautioned General Phahlane to say he must be very careful of the Minister of Police, Mr. Nathi Mangshleku, and the former head of the Director Priority Crime Investigations, Major General Meza, who were allegedly behind the attacks on McBride and on General Phahlane. To his surprise, McBride offered assistance and said that they must now work together in dealing with these people who are trying to get them out and destroy and replace them by people of their own. General Phahlane's response to Mr. McBride at that time was that he's got nothing to worry about. The allegations made in the media against him, there was nothing that he needed to fear about, because he knew there was nothing that he did wrong on his part, and he even are the one who went that and requested that all these allegations be investigated, and he wanted to be done on a thorough basis, so that if he's been implicated, that he should go then and be held accountable for any wrongdoing on his part. Then on the 5th of June 2016, General Phahlane and his wife was under attack by 3 gunmen while they were at a spa in Dunkeld, Johannesburg. And then the same night, he even get a message from Mr. McBride, where Mr. McBride sent him a text message and say, "Just heard, sorry about that. Let me know if you need help. Offer still stands." General Phahlane then told him, or just responded by saying, "Noted, with appreciation, kind regards." Then a few months back in 2017, we found out that it was McBride who obtained a copy, because shortly after this attack, there was a video that was circulated on YouTube and all things about what happened at the spa. And it was to his surprise how investigators would now let this leak out. And this is why in 2017 he found out it was Mr. McBride who obtained this video footage of the spa. And this was then forwarded to Mr. O'Sullivan and his assistant Sarah Jane Trett. And it was also circulated to the media by one of the journalists, Mr. Peter Louis Maiber. And this video just went all around the country, and Mr. McBride then returned to office in October 2016. Paragraph 52 of his statement did say that on the 14th of November 2016, he received a call from a Mr. Fritter Blanche, the building contractor of his house, who then informed him that he was approached by people who told him that they were conducting an investigation on the building of his house in Sable Hills Waterfront Estate. Smith indicated that 4 people, a white male, white female, and 2 African males, approached him at the creche in Seneville, where his wife was rendering services. The leader of the 4 identified himself as Mr. Paul O'Sullivan, who was leading during the interview and questioning in relation to the construction of General Phahlane's house. He immediately reported this to General Phahlane, as he also found it strange that he get questioned regarding this building of the house and what is going on. He also informed, seeing that he did not know if General Phahlane got the message, immediately informed his driver, Captain Alvin de Pre, to inform General Phahlane as soon as possible of the incidents that occurred. Then on the 16th, 2 days later, the same people went back to Mr. Smith at his the creche where his wife was working, and they wanted him to make a statement, and he said that he was thinking, and later got a text message from Sarah Jane Trett, which read as follows: "Dear Sir, IPIT investigation. I confirm that the case number as CCN 201603085. A meeting is arranged for 1100 on Friday at IPIT's office, City Forum Building, 114 Madiba Street, Pretoria, nearest corner Schubert Street. We have confirmed that your status is a witness, not a suspect. You are, of course, welcome to bring an attorney with you. If you like, we look forward to seeing you then. Regards, Sarah Jane Trett." Now, it was because of the second call and things that General Phahlane decided that he needs to bring this under the intention of the crime intelligence to be investigated, because it was strange why private persons are now going around questioning the builder of his house, want to get plans of the house, all things like that. And he thought this is not normal. He needs to report this to the crime intelligence so that it can be seen, and they must decide whether it needs to be investigated, as he was at that stage been appointed as the acting national commissioner. And it looks like it could have been a threat against the acting national commissioner. This was then indeed been done, and General Makele, the head of the crime intelligence unit at that stage, the acting divisional commissioner, decided that an investigation should be done by the crime intelligence services itself. Because of the investigation that was being done by crime intelligence and the report that was being forwarded to General Makele, a decision was then being taken to appoint a totally independent team that was from another province, northwest, to investigate this matter and to find out the involvement of O'Sullivan, Sergeant Trent and all this, because it did not seem to be correct, and if there was any wrongdoing and if there's any threat against the General Phahlane at that stage. Sorry, Chair, I'm just looking quickly. Yeah, General Phahlane at that stage was, when this all happened, he was in Limpopo with a strategic planning session with other members when he was informed about all of this. And on his return, he then was invited to have a strategic session with Lieutenant General Bonang Mngwenya and the former Major General Sabia of the DPCI, that requested to meet with him and Mr. McBride. He was persuaded and went to this meeting in Centurion at the Lariba Lodge on Friday the 18th of November 2016. And it was during this meeting once again that he urged Mr. McBride to ensure that a thorough investigation be conducted in allegations against himself. He further cautioned him about the involvement of Mr. O'Sullivan in the investigations. Now, we know now that despite that, Mr. McBride did not stop the involvement of Mr. O'Sullivan. Mr. O'Sullivan just continued on with the investigations against Phahlane, although he was not an investigator, permitted to do so. Then on the 22nd of February 2016, General Phahlane received a telephonic call from Mr. Cedric Nkabinde, who was at that stage an investigator from IPID, who informed him that he is now investigating charge of defeating the ends of justice against General Phahlane, which was registered under Kameeldrift CAS 123/11/2016. The reason for Nkabinde's call was to secure an appointment, and of course he wanted to obtain a warning statement from General Phahlane regarding this allegation. There was then arrangements made that General Phahlane would meet with Mr. Nkabinde on the 23rd of November at around about 2 o'clock in the afternoon at the IPID offices. Unfortunately, due to other more important matters that are raised, General Phahlane had to cancel the deal the appointment with Mr. Nkabinde. But what is of note here is that on the morning of the 23rd, it was shortly after 8 that General Phahlane received again a text message from the journalist Mr. Meyerberg, which reads as follows: "Hi General, this is Peter Louis Meyerberg from News 24. I was hoping to get your comment on the iPad matter. I understand you've been asked to make a warning statement. Thanks." Around 9 the same day, it was breaking news all over the media, News 24 and other media platforms, that General Phahlane now suddenly cannot attend this. And it was headlined as Phahlane no show at IPAD. So that is clear to point out to the chair and this commission how IPAD and Mr. O'Sullivan worked together and involved the media to put any negative publicity, whatever they can get, against General Phahlane. This matter that was referred to of the defeating the ends of justice was, despite obtaining General Phahlane's statement, warning statement, it was processed to the NPA for decision, and due to the lack of evidence, the NPA declined to prosecute in the matter. But despite that, there was another case being opened, Sinnerville Cas 146 of 527 for corruption and fraud, which involved an alleged receipt of gratification in the form of vehicles from a person not doing business with the SAPS. Now, this matter was in June 2018 struck from the court roll, and to date it has not been returned. And it is clear that the Rationality view is that it's because of the lack of evidence that there was any wrongdoing on his part. Or there was any corruption involved. This was clear, not a corruption matter. It was explanations was given, and I think that is also the reason why the matter is not returned yet after June 2018. Just want to go. Sorry, apologies, Chair.
I think you left with about 7 minutes.
Yes. So, yeah. Then, Mr. McBride created the impression that there was counter investigations, and he was the one who implicated that General Phahlane is the one. Now, clearly, what we've read here, it was General Makele who was at first requested the Crime Intelligence Unit to do an investigation, and after the report back to it, then it was decided to include the Northwest team under General Mabule to investigate. It's also of note to commend that investigations was being done with the NPA. It was an NPA-driven investigation. They were in charge, and they were the ones who gave General Mabula and them leads what to do, what they need to decide if prosecution would then be instituted or not. It's also of note that Mr. O'Sullivan, as well as Ms. Trent, and 2 IPAD members were later arrested on this incident. The matter was withdrawn, but I believe that the investigation is still with the NPA, and that matter might return to court, as Mr. McBride and he was also implicated in that matter. Now, it's also of note to say that Mr. Nkabinde later on made a full affidavit regarding, he called it the Phahlane team that was formed to investigate matters against him. And there was a lot of things that was being reported to the Ombudsman, to the Parliament, Portfolio Committee, and all that. I think everybody knows that there was a big thing in the media as well regarding that. And even after Mr. Nkabinda was then unlawfully being suspended for then blowing the whistle on IPID regarding this. Now, General Phahlane is of the view that Mr. O'Sullivan, even during the Portfolio Commission, made a comment to say it's not IPID, it's O'Sullivan police in investigations against him. And it's not like the legislator wanted IPID to conduct, but they were now fully under what O'Sullivan wanted them to do and not to do and who to do. You have heard also this morning, General Phahlane also received several emails where he was threatened if he does not want, when he was in the position of acting National Commissioner, to suspend General Munu, who were the allegations against made by O'Sullivan. There was numerous things, and then during these emails as well, that's in front of the Commission, O'Sullivan has also threatened that should he not comply with it, the focus will then turn to that of against Phahlane. And we, General Phahlane and ourselves will review. This is also the reason why then they decided to approach the Commission. It's clear that the allegations which they made has got nothing to do with state capture. There is no state capture. There was the allegations made that the NPA favoured our client, which is totally, I mean, we've heard it this morning from the NPA itself, that they did their decisions independently, objectively, and according to law. On the one of Mr. Sissoko, if I can end there with the Chair,
yes,
that I just want to make there is that it was to General Phahlane's surprise that Mr. Sissoko suddenly dragged him into the Rendition matter and made allegations against him that he was involved in the Rendition matter, which is clearly false and baseless. Never was General Phahlane ever involved in any investigations or even implicated by any persons previously. It was only now suddenly done by Sissoko. This clearly showed the maliciousness that I put by names of Mr. Sissoko and then Mr. McBride have against General Phahlane. They want to implicate him in matters which he's not even involved in. And therefore, he also found it very surprising and strange and also disturbing that he get dragged into matters where he was never involved with. So I think that basically would sum up the summary just involving General Phahlane's application. That the allegations, it's clear this allegations is baseless. There is no evidence that there was any wrongdoing. The matters was investigated. There is still matters. We concede to that. That is currently in front of court. And yes, the outcome of that will be, surely it's a matter that the public will know about. But General Phahlane also leave that as sub judice as the matter is in front of court. The other cases, like I said, was thoroughly being investigated. It was being decisioned by the NPAs, and that the reason to implicate him in state capture was malicious and wrongfully.
Thank you, Mr. Exgen. Thank you very much. So it will be recorded that therefore the cross-examination will not proceed, and Lieutenant General Phahlane has had the opportunity of having you giving a summary of his response to the evidence of Mr. Sissoko and Mr. McBride. Thank you very much. Mr. Halley, did you want to say anything? I don't think so, but
no, Mr. Chair. I merely wish to record once you've completed.
Yes.
That wraps up or brings to a conclusion the affairs of the Law Enforcement Agency work stream for the day.
Yes. Okay. No, that's fine.
Thank you, Chair. I just want to say that General Phahlane thanks the Commission for affording him the opportunity to put his side.
Yes. No, thank you very much. We'll adjourn for the day, and you are now excused. We adjourn.